You are watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman and I am a local attorney with the law offices of J. Vincent Perryman. Each month, Law Talk focuses on a wide range of legal issues and topics. Today's show will talk about bad faith claims. With us now is attorney Wes Fowler. Wes, thanks for being with us. I know you and the Fowler Law Firm do great work, and bad faith when it comes to insurance claims is kind of an odd area of the law to a lot of people, and they don't really know what that is. So I guess a great place to start is, what are we talking about when we say bad faith claim?
Well, it's changed. Thanks for having me, Vince. The answer to that question's changed a lot in the last 5 or 10 years. If you had to put it in a nutshell for folks, insurance companies have several duties to insureds, to the people that hold insurance policies. And the persons who hold insurance policies have a duty or two as well. But when the insurance carrier doesn't uphold those duties, especially if they do them in a manner that's not fair or equitable, and if they do it knowingly, that's what bad faith is. That's in a nutshell, and we're going to go over that more closely here in a little bit. But that's what it is. I think first, for folks to understand what bad faith is, they need to understand some basic terms. There's a thing called a first-party bad faith claim and a third-party bad faith claim. And the big difference is whether, if you're bringing a claim for your loss, your damages, that's a first-party claim. If someone else has damages and is suing an insurance company, that's a third-party claim. And the rules are different for each one of them. First, the duties everyone has. People, you and I, for your insurance company and myself for my insurance company, I have a duty to cooperate. If a claim is brought, I have to cooperate with them and help them defend it. Likewise, and that kind of segues in, the insurance carrier has a duty to defend and a duty to indemnify, and they're different. The duty to defend is broader than the duty to indemnify. The duty to indemnify means the duty to pay when there's a claim. When a claim's made against you, you pay those premiums every month, believing that if you get sued or something bad happens, your insurance carrier is going to come in and defend you. That's a very broad duty. And that's where you hear the term reservation of rights. Sometimes they will defend the case, the carrier, with a reservation of rights. On the other hand, the duty to indemnify is a little bit more narrow, but it's still there. You have insurance to pay in the event there's a loss either to you or to someone else that is because of your conduct or negligence. So those are the first things I think someone needs to understand. Now that we've talked about first and third party claims, what exactly does bad faith mean?
Well, and let's back up for a second, because when we're talking about insurance, that's kind of broad. We're talking about when you're insuring yourself against liability for something. Is that correct?
In general terms, yes. Now, there can be other bad faith denials of lots of different types of insurance claims. Those are typically first party claims. If your insurance carrier doesn't pay under a disability policy or any type of policy, there may be a bad faith claim there. That's not as much what I'm talking about here today. The rules can be similar, but they're not the same. And it's different because the duties that a carrier has run to its insured only. In other words, if I were to cause an accident and you were hurt and you sued me, my insurance company would come in, but its duties are to me and not to you. Right. You can't sue my insurance company directly. It's called a direct action, and it's not allowed in Tennessee. Very few states do allow that. But the duties the insurance carrier has, whatever they are only to the insured. Okay? So in any event, bad faith claims, one thing I want to briefly say, because I think it'll probably come up later, is whether they can be assigned or not. Can you assign a bad faith claim? And that becomes problematic for plaintiffs' attorneys who are bringing a claim against an insured whose carrier isn't playing by the rules. Because I can't sue them directly, as we just discussed. Can that person, at the end of the case, after we have a large judgment against them under this hypothetical, can they assign that claim to my client to pursue? And I've heard yes at CLEs, I've heard no at CLEs, and I've read blogs that say it both ways. The case that actually controls is called Kame versus Maryland Casualty Company, Zurich now, I think, 346 Southwest 2nd, 259, Tennessee, 1961. And what it actually says is those claims can be assigned if they meet the test of assignability. That's a little more complex we need to get into, but my point is sometimes yes, sometimes no. That blanket bright line rule everyone thinks is out there isn't really the law in Tennessee. Now, what are the remedies? If your insurance carrier doesn't act right, for lack of a better term, what can you do? The first and most obvious answer is something that lawyers refer to as the bad faith statute. It's a statute in Tennessee. You can find it by searching on Google 56-7-105. And the statute does have in its title the bad faith penalty statute, but it does not speak in terms really of bad faith. What it actually says, the parts that are important, is in all cases when a loss occurs and the insurance company refuses to pay that loss within 60 days of a demand, if they're found to have done that without good cause, basically without proper investigation, et cetera, they'll be responsible for, at the judge's discretion and only upon certain findings, an additional penalty. That additional penalty is three things. A lot of folks think it's just a 25% penalty, but that's not true. It's a 25% penalty plus the compensatory damages of the claim itself and interest thereon. Now, it's kind of a toothless statute in that respect because you're already entitled to those things. If you win against your carrier in a suit for not paying a claim, you're entitled to recover your compensatory damages already. It's a liquidated sum. You're entitled to recover interest already, prejudgment interest already. So the statute is a very toothless statute. Even the 25% penalty, which seems significant, really isn't, because attorneys have to take those cases, and they typically charge, as you know, how much?
A third.
A third is fairly standard. Sometimes it's more than that in challenging cases, and these are all challenging cases. There's no such thing as a simple bad faith claim. They're very complex. So attorneys typically charge more than a third. So you're going to pay your lawyer 40% of what you recover and get an extra 25%. That leaves you in the hole, doesn't it?
Yep.
So it's a toothless statute. And carriers and the legislature recently have worked very hard to make that the only remedy to an aggrieved insured. It's unfortunate, and it's thanks to some good decisions by some of our local judges and some of the judges in other districts, it's not really the law anymore. There are extra contractual damages available against carriers who don't play by the rules, at least if they go far enough outside the bounds of common practice. And we'll talk about that probably in the next segment. I don't know how much time we have left in this one.
Oh, we're still going on this one.
Okay, so that statute, toothless as it may be, is still important, and you've got to bring it. But what does good faith mean? So you only win under that statute. You have to win and show there was coverage, and it was the insurance carrier got it wrong. But you also have to show not really an element of malice, but bad faith. How do you do that? What is good faith? I have some examples that I found on a really nice blog by Brandon McWhirter. And some examples he gave is, well, an insurance company should not make a strained interpretation of an insurance policy. I agree. And an insurance carrier shouldn't read a policy in a way that they know doesn't make any sense just to get the result they want. That probably will be bad faith given any other facts that would lean in that direction. Attempting to settle a claim for less than what they know is owed under the policy. If a carrier tries to basically negotiate with its insured for less than it clearly owes, that's bad faith. Trying to condition a payment of one portion of a claim until the entire claim is resolved or on the resolution of the whole claim. If you clearly owe one claim as a carrier, you've got to pay that. You can't condition it on the insured cooperating in a way that's, well, not cooperating, you've got to cooperate, but a particular result in another area of the policy or the claim. The one I see the most often is where a carrier does a kind of an Olay investigation, doesn't really investigate the facts of the case, gives a denial for whatever reason. Sometimes it's because I've seen it in situations where they just thought they could get away with it, where the adjuster, maybe they're busy, but a client who happens to be Hispanic doesn't speak good English. They deny it thinking they'll never, I guess, figure it out. Sometimes they do, though. Most of the times they don't.
Well, and that's a good spot for us to take a break. When we return, we'll continue our discussion about bad faith claims. Please stay with us.
Don't worry, 74 people were picked before me in the NFL draft.
To fight childhood obesity, United Way and the NFL are helping kids play at least 60 minutes a day.
Okay, time for the team obstacle course. Yay!
What this place needs is more healthy kids. To get involved or donate, go to unitedway.org/play60.
Now I get it.
Looks like it's done.
Don't let salmonella get funky with your chicken. On average, 1 in 6 Americans will get a foodborne illness this year. You can't see these microbes, but they might be there. So learn the right temperature to cook each type of meat. Keep your family safe at foodsafety.gov.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. I'm Vince Perryman, and you are watching Law Talk. Joining us on our show is Wes Fowler of the Fowler Law Firm, and we're discussing bad faith claims. Wes, when we cut to a break, we were talking about what are examples of bad faith, and I think you had a couple more examples.
Yeah, and there's even more than that, and I may get to those later if we have time, but it's a hard thing to put your finger on. Bad faith is not an easily defined thing. It's kind of like obscenity and pornography. You know it when you see it, but defining it's a little difficult. The last two things I had on this preliminary list that came from Mr. I think it was Brandon McWhorter's website, was that an insurance company can't rely on biased or speculative information or opinions in denying a claim. In other words, you can get an opinion, just about any opinion you want if you pay for it. But if it's clear that that's a unreliable opinion and the carrier uses it as its basis to deny a claim, that's probably going to be a finding of bad faith if the proof shakes out that way. Insurance company must treat its insured's interest equal to that of its own. There's a fiduciary relationship. That means that you as the insurer, you're not just the insurer of the business, you're the insurer, the fiduciary of your insured. Their interest must be treated at least equal to your own. And that's very rarely the way adjusters actually see it. Some of them do. I don't want to disparage an entire profession, but oftentimes I don't think adjusters always understand that that fiduciary obligation is there. You can't act out of self-interest when you're an adjuster. You have to act in the interest of the insured. Now, one thing to understand, these are hard claims. So if it sounds like this is easy, they're not. And understand that even under the bad faith statute that does not have a lot of good remedies under it, a legitimate difference of opinion is not bad faith. If the adjuster, if it's a new area of the law or it's a close call, that's not bad faith. If the adjuster just disagrees, then it's not bad faith. It's when it's clear that an honest effort's not being put forth by the carrier to evaluate and if proper pay the claim.
Right. And a lot of times where I see something like that is when somebody tries to take care of their claim themselves without an attorney. Well,
yeah, the instance with the Hispanic client of mine that I was just referring to was when they were pro se. The claim would have never been denied if they had a lawyer. Should never have been denied anyway. Now the next thing, and hopefully I have time to get through at least this part, because this is what I think it's important for folks out there to understand. The bad faith statute, the legislature tried to make that the only remedy recently, and that was because there was a case, great Supreme Court case. I think Justice Holder might have been the one writing the opinion, but I don't remember for sure. But the case is called Myatt versus Allstate, and it made the Tennessee Consumer Protection Act apply to insurance companies. What it said is, like every other business in Tennessee, if an insurance carrier commits an unfair or deceptive trade practice or act, they are responsible for what are some great remedies. And that protected consumers fairly well. Not as well as I'd like, but fairly well. Unfortunately, our legislature took that away. And they did that specifically for the purpose of protecting insurance companies, because that's exactly what it does. For a while, everyone thought that was the only contractual remedy. And there's a quote I'll read from that same website that I agree with. It's the saddest part about the new law is that it sends a clear signal that insurance companies are above the law, that ethical conduct is required of all businesses in this state except insurance companies, who are free to act unfairly and deceptively without the threat of private recourse via the consumer protection statutes. And he goes on to very articulately explain his objection to that. And I share that objection. I think every Tennessean should. Why are you protecting an industry that clearly doesn't care about you, the citizen? Why are your legislatures doing that? You should ask your senators and congressmen that question. This was the status of the law after Myatt was abrogated by the legislature just a few years ago. But, like I said, some good case law from good judges have added or clarified that there are still extra contractual remedies. That means punitive damages potentially, damages above what you actually lose if an insurance carrier acts bad enough. One of those cases, and if you want to read a book, maybe want some heavy reading, there's a book called Delay, Deny, Defend by Jay Fineman, F-I-N-E-M-A-N. And I've got a long quote, and I'll read it if we get to the end and have time, but basically he goes through nationally a pervasive epidemic of what is bad faith throughout the country. And in a lot of jurisdictions, what's happening in Tennessee is happening. Oddly, Florida has resisted better than Tennessee has, which is very uncharacteristic in protecting consumers. It is truly unconscionable what's happening across the country. So, what is the remedy now? First case I'll talk about is a case called Ryad versus Erie Insurance in 2013. That's a Tennessee Court of Appeals case, very good opinion. And essentially, it did limit that holding to the most egregious of cases, but punitive damages are always limited to the most egregious of cases. In short, when a carrier denies a claim wrongfully, if you can show they did it under this loose, very hard to define standard of bad faith, which borders on intent, you can recover punitive damages now. Several other cases in Tennessee, or the federal courts interpreting Tennessee substantive law, which is what we're talking about here. One is New Hampshire versus Blackjack, and that's a very recent 2015 case in federal court. And it confirms this trend. There are 5 or 6 of these cases, finding that an insurer's failure to follow a policy can amount to bad faith. In other words, the bad faith statute is not the only remedy for consumers anymore. Let's see, the next one is Brooks versus Tennessee Farmers, and that was a 2014 case. It actually, I think, probably was a case that was filed at the time Myatt controlled, so Consumer Protection Act did apply, but the take-home, or at least I think it did, but the take-home is that Tennessee Farmers was using basically take-it-or-leave-it offers, and that was found to amount to what is essentially bad faith. There could be found to be bad faith. You can't give take-it-or-leave-it offers. So the next case is called, Carroll versus Nationwide Property and Casualty, another 2015 case. And the reason I'm excited about this one is it's one of our local federal judges, Thomas Anderson, wrote a great opinion finding that where there is a breach of the policy that is intentional, malicious, reckless, or malicious, punitive damages may be awarded in an insurance policy setting. So, yes, you lose the great Consumer Protection Act and all the awesome remedies, attorney's fees, treble damages, a standard that is very clear. Is it unfair or deceptive? If it is, you win. That's gone, but at least there's still something there where under the right set of facts, you can hold an insurance company responsible for horrible actions connected with your insurance policy.
Yeah, which is great because they've got a huge lobby that we don't necessarily have as consumers.
That's why that statute got passed. Clearly, I mean, this Brandon Merriweather's blog talks about calling all the senators before trying to.
And it's always interesting on that. When we return from our break, we'll talk more with Wes Fowler about bad faith claims. Please stay with us.
So they say it's a man's world? I don't see anybody's name on it.
While they were doing their thing, we slowly changed all that.
Today, women can do anything men can do. And there's one thing we're even better at.
They're coming. Places, everybody.
Light check. 1, 2, 1, 2.
Everything looks good on our end.
And lights.
Come alive with the forest. Visit discovertheforest.org to find a forest near you.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. With us now is attorney Wes Fowler of the Fowler Law Firm. We're talking about bad faith claims. Wes, we've gone into what is a bad faith claim and the case law behind it and everything, and where we stopped kind of in the last segment was talking about the uneven power of the insurance company's lobby versus that of the consumer. It's one of those that I think that's why it's so important that we're sitting here educating the public on bad faith claims, is because of that inordinate power. So,
yeah, it's true. I mean, there are a lot of powerful lobbies in Nashville and in the legislatures across the country. This one may be the most powerful in Tennessee anyway. Insurance carriers have made the laws that purport to regulate them for decades, but it's getting more and more direct. The amount of lobbying, the laws allow lobbying in this form. I don't like it. I think a lot of people don't like it, but it's an invested system, so we're probably stuck with it. The two things I've got left to do, at the end I'm going to read, if we have time, a quote from that book by Mr. Feynman. In the meantime, I have some other examples folks can look for. If you ever have a claim with an insurance company and any of these things happen, that should maybe raise your radar that the carrier's not doing the things that it should do by you. I've already heard about take it or leave it offers. If an insurance carrier gives take it or leave it offer, call an attorney. Probably want to call an attorney anyway if anything seems fishy at all on a first party or third party claim. Where there's clear liability and significant damages, but the carrier goes to trial anyway without offering policy limits, that is a red flag for me generally. There may be some issues with bad faith and not looking after the insured the way they should. Attempting to ask the insured to pay part of the settlement, arguing, well, this is close issue on coverage, so we'll pay 70%, you pay 30%. Always raises my hackles and my antenna, but maybe there's bad faith here. If it doesn't look like there was really a real investigation or an honest investigation into the facts, and they deny based on facts that you think are inaccurate, that may be something you want to see an attorney that understands the bad faith law about. Where the carrier rejects their own lawyer's advice. That's done more often than you would believe, and they may not overtly reject it, just not follow up on it, not respond to emails. And the next one is very closely related to that one. In-house counsel. Carriers in this state now don't hire lawyers outside of the outside counsel nearly as often. They have their own lawyers who are employees of that insurance carrier and are supposedly looking out for the interest of the insured. Well, if your boss had an interest in paying as little money as possible and you supposedly are supposed to take care of an insured, where does your loyalty really lie? It creates all manner of potential conflict, and there's a great case talking about that called In Re Youngblood. I say great case. Wrong result, great case. All the potential conflicts recognized in Youngblood have come to pass because of in-house counsel. So if there's a staff counsel on your case, I'd call a lawyer. I'd get separate counsel on any case where an insurance carrier used their own employee to defend me. You're supposed to have an independent lawyer, in my opinion. I think that your policy entitles you to that. Where a carrier doesn't tell the insured about an offer, gets an offer, rejects it, never informs the insured. Insured might have said, you need to take that. Here's why, to protect me. Where they try the case without negotiating because the demand is over our policy limits. That's actually the facts of a case that are not that long ago in Tennessee, and the carrier, I want to say it was Tennessee Farmers again, his position was, well, the demand was more than our limits, so we didn't feel we had to negotiate. Wrong, that's not the rule. You have to negotiate. If you don't, it's bad faith. You have to try to protect your insured, settle the case within their limits. When there are no real attempts, similarly, no real attempts to resolve the claim, the carrier has an obligation to try to resolve your claim within policy limits. And if it doesn't and you get popped for an excess judgment, and that's maybe something I assumed everyone knew, but this whole idea of bad faith, the bad faith claim, say that you get sued and your carrier does not settle the case, and maybe they should have, and maybe they clearly should have. You have $1 million in insurance coverage, verdict against you for $3 million. That's collectible against you individually. The bad faith law, if you were to prevail, would require the carrier to pay that additional $2 million and, of course, the policy limit of $1 million. So people need to understand that. It can be really bad and really important. Also, if a carrier gambles, essentially, with the insured's exposure to risk. If it could go either way, no skin off our nose, and then there's a big excess judgment, I think that's bad faith. These claims are almost always proven through circumstantial evidence. No one admits, yeah, I was guilty of bad faith. So you've got to raise inferences of bad faith. That's how they're proven. Circumstantial evidence has convicted people of murder. It certainly can prosecute a carrier for a bad faith refusal to settle a claim. And now I'll read, if we have time, this little quote.
We've got time.
Okay, this is, I mean, a carrier would probably say this is hyperbolic, but I think it's accurate. This is in quotes. Do you think your insurance policy has your property protected from life's many mishaps? That those premiums you pay every month guarantee you the help you need when you need it? That your insurance company is a benevolent entity that strives to pay claims fairly and promptly? Think again. Your insurer's main objective is not to protect you. In fact, insurers often try to avoid paying justified claims. Today, the name of the game is delay, deny, defend. To improve their profits, insurance companies delay payment of justified claims, deny payment altogether, and defend their actions by forcing claimants to enter litigation. It's unconscionable and it's widespread. From stonewalling and lowballing claims to instigating arbitrary fraud investigations, Insurance companies are increasingly failing to live up to their contractual commitments. Some major insurers even hired the big-name consulting firm McKinsey to help them squeeze even more cash out of their claim centers. Why? Because insurance companies have realized they can add to their bottom line by using your monthly payments as a profit center rather than a fund for giving you what you deserve if tragedy strikes. And again, that's from Mr. Feynman's book, J.M. Feynman, and it's a good read.
Yeah, and that's the thing is that you've got sort of this overwhelming process there where I've seen adjusters, when somebody is trying to represent themselves, go as far as to tell them that the statute of limitations runs on a different day for a lawsuit.
Wow, that's I've never seen that. That would be...
Yeah. Well, and it was interesting. It was a specific adjuster that we would see again and again doing stuff like this. So basically anytime that insurance company came up, it was, we're not going to negotiate, we're just going to litigate. And eventually that adjuster got taken off of all of my cases. I think once I was at a networking event where somebody was selling insurance for that company and pointed out that you got this one rogue guy, I can't recommend you because he won't even pay out on your own insured.
Yeah.
You know, so this has kind of been the odd thing with all of this and bad faith, getting people to understand it, because I think once the public understands it, we've got a better opportunity of actually getting our state legislatures to do something about it, as opposed to working on our, on the lobby of the insurance company and saying, oh, okay, you're going to donate to my campaign? Yeah, I'll do this.
Yeah, absent that statute that abrogates Myatt being found unconstitutional somehow, and I don't really see how, we're probably going to be stuck with what we have now unless a really, really horrible thing happens and publicity is such that pressure is put on the elected officials such that they worry about being elected again.
Yeah, and I think that's a great place to stop. Our time is up for this edition of Law Talk. I would like to thank our guest for taking time out of his busy schedule to be with us and for sharing his thoughts and insights about bad faith claims. If you'd like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next month for more discussion on legal topics. Until then, I'm Vince Perryman, and thank you for watching.